My name is John Medjugorje, and I'm an attorney here at the firm of Ginarte, González Winograd. One of the most common types of cases that comes through our doors are slip and fall accidents. A lot of times the slip and fall accidents occur on sidewalks, and this is either due to sidewalks that are in a state of disrepair, either because they're upraised or cracked, or another common fact pattern is where the sidewalk is covered with snow and ice. Now, when a potential client comes to our office in a sidewalk slip and fall accident, the first question we're going to ask is, where did the accident take place? This allows our office to identify potential defendants as well as to evaluate the merits of the case. And this is particularly important in New Jersey, where since 1981 the Supreme Court here has held that only commercial landowners are responsible for reasonably maintaining the sidewalks abutting their property. Courts looking at sidewalk liability have often focused on whether the sidewalk or the property abutting the sidewalk is considered commercial or residential. Today my blog takes a look at that distinction and an effect that it had on a case that our law firm handled last year. That case went to the appellate division in an appeal handled by myself and Michael Gallardo, and I'm happy to say resulted in a favorable outcome to our client. The case is Grijalva v. Florio, and the site is 431 NJ Super 57, Active 2013. Now, the facts of Grijalva start out simple enough. Mr. Grijalva was injured on an ice-covered sidewalk. He broke his leg. And the property that Mr. Grijalva fell in front of was an owner-occupied two-family house that we allege was turned into a three-family house when the owner moved from the second floor apartment to the basement apartment. So the issue really became, was that property considered commercial or was it considered residential? Because if it's commercial, then the owners would be liable to Mr. Grijalva for not clearing the sidewalk of snow and ice. Or if it was residential, then Mr. Grijalva would get no money whatsoever because, as a matter of law, the defendants didn't have any responsibility in the first place to clear the sidewalk. Just so you know, an example of a commercial property would be a business or a large apartment complex. Something that would be considered residential would be an owner-occupied single-family house. And in Grijalva, the property was kind of mixed. On the one hand, it was commercial because she rented out 2 floors of the two-family house, but on the other hand, it was also residential because she lived there. So when the judge first heard this case, she found that the case really should result in no money to the plaintiff because the property should be considered residential. We figured that this case, we felt very strongly that this case should be considered commercial, and so we appealed to the appellate division. And when the appellate division heard our case, they actually agreed with us and remanded the matter for further proceedings. They reversed the motion judge. The appellate division kind of laid out 4 factors that will help future cases be resolved when you look at the commercial residential distinction. The 4 factors are the nature of the ownership of the property, including whether the property is owned for investment purposes. The second is the predominant use of the property, how much does the owner actually live in versus how much does she rent out. The third one is whether the property has the capacity to generate income. And the fourth one is any other relevant factor when applying commonly accepted definitions of residential or commercial. After it went to the appellate division, the case ended up settling, but it is a published decision and it is going to help future cases be resolved when they look at this issue. Thank you very much.